A meeting at the Vatican has sparked a surprising new debate. Could the Catholic Church's practice of ordaining only men someday face a legal challenge in European courts? That question is now being discussed by a group of French legal scholars after Pope Leo XIV's meeting earlier this year with Sarah Mullally, a senior Anglican leader. Their argument is attracting attention because it shifts the discussion away from theology and into the world of civil law. The controversy began after Pope Leo XIV received Sarah Mullally in April. Mullally serves in the Anglican Communion, where women can be ordained and hold senior leadership positions. According to an article published on July 12 in the French newspaper La Croix, several French academics viewed the meeting as an event that renewed public discussion about the Catholic Church's male-only priesthood. The scholars said the meeting created both astonishment and hope. Why? Because it highlighted a visible contrast. In the Anglican tradition, women can serve in ordained leadership roles. In the Catholic Church, priestly ordination remains reserved to men. The academics argued that this difference should now be examined not only from a religious perspective but also from the standpoint of modern anti-discrimination law. They wrote that excluding women from ordained ministries appears difficult to justify when viewed through ordinary legal standards concerning equality. The scholars also pointed to the Church's ongoing prayers for priestly vocations. They argued that such appeals continue to promote a vocation that is currently open only to men. For them, this raises questions about whether the existing practice remains legally acceptable under contemporary European legal principles. Importantly, the authors did not focus on challenging Catholic doctrine directly. Instead, they proposed moving the debate into the civil sphere. They argued that issues involving equality between men and women and the prohibition of discrimination belong within the jurisdiction of European legal institutions. Their legal analysis claimed that reserving ordination exclusively to men could be considered what civil law describes as direct discrimination. Their reasoning is that women are categorically excluded from positions that involve governing, teaching, and sanctifying authority within a church. Because the distinction is based explicitly on sex and applies without exception, they believe it fits the legal definition of direct discrimination found in French and European law. The scholars also cited international legal principles that encourage governments to combat discrimination, even when such practices are rooted in long-standing institutions or social traditions. At the same time, they acknowledged a major obstacle to their argument: religious freedom. They noted that the European Court of Human Rights has consistently recognized broad autonomy for religious communities. That autonomy includes the right to establish their own internal rules and determine qualifications for religious offices without government interference. However, the scholars argued that this autonomy should not be considered unlimited. Referring to European Union law, they maintained that differences in treatment based on religion must be legitimate, justified, and open to judicial review. According to their analysis, the central legal question is whether biological sex can be considered a valid qualification for priestly ministry. They argue that using sex as a criterion creates a hierarchy among believers based on gender. They also suggested that the issue extends beyond Catholicism itself. In their view, it raises a broader question for democratic societies: how far religious autonomy should extend when it appears to conflict with principles of equality and fundamental rights. The article concluded with a strong statement. The authors argued that equality between men and women should apply to all areas of society, including institutions that claim religious autonomy. The Catholic Church, however, has consistently maintained a different position. In 1994, Pope John Paul II stated in the document Ordinatio Sacerdotalis that the Church has no authority whatsoever to confer priestly ordination on women. He further declared that this teaching is to be definitively held by all the faithful. For now, the debate remains theoretical. But Pope Leo XIV's meeting with Sarah Mullally has clearly reopened a conversation that touches on law, religion, religious freedom, and the future relationship between church teaching and modern legal systems.